with me now in studio is Moses Kajwang, the Senator of Homa Bay, and also Kimani Ichungwa, the Member of Parliament for Kikuyu. Gentlemen, thanks so much for joining us on NTV tonight. Now, the Auditor General is certainly reading malice into all of this. Kimani, I'll begin with you. Is this a way of hounding him out of his office?
Well, I don't think anyone is interested in hounding him out of office. And all that Parliament is doing is carrying out our constitutional role and mandate given by the Constitution, that if any Kenyan wants to remove any member of an independent commission or independent constitutional office from office, then you petition the National Assembly or Parliament to commence the process of that removal. But the parliamentary process is not an end by itself. It just actually is a fast process. Once they're in receipt of the petition, you look at whether the petition warrants to be looked into by Parliament. And you let that process go on. Then if there is reason to believe that there is sufficient evidence to remove someone from office, then you propose, or rather the parliamentary committee would propose the setting up of a tribunal by the president. Therefore, really, I don't know why the Auditor General all of a sudden has become very jittery and agitated and wanting to rather prosecute the petition in the court of public opinion. Remember, the Auditor General, and that was the concern I was expressing this afternoon in Parliament, that the Auditor General moved to court because he said he did not have confidence with the process in Parliament.
Right.
The matter is still pending in court, and the petition is still pending before Parliament. So you beg to ask whether the Auditor General has lost confidence with both Parliament and the judiciary,
right?
And now wants to prosecute his matter in the court of public opinion, a court where the public have no way of measuring evidence.
Right. Moses, let me bring you into this. Is it fair to say that really the Auditor General is now taking this out to the Court of Public Opinion?
Well, he's taking it out to the Court of Public Opinion because he's seen clear evidence that is trying to be fixed by those that he's supposed to oversight. We must remember what the role of the Auditor General is. It is a role that is enshrined in the Constitution, and this is a guy who looks at the books of government and tells us whether government is spending money well or not spending money well. This is a guy who goes to check whether Eurobond, if it indeed came to Kenya, and whether it was utilized properly. If there is anyone with an interest in fixing the Auditor General, it can only be the national government or the county governments or independent constitutions whose mandate it is his to oversight. So I have the feeling, and I am convinced, that there are some forces that are out to hound Edward Ouko out of office. And I'll give you evidence of that. These are not new allegations. These are issues that the EACC had commenced investigations on and made recommendations to the DPP to prosecute. The DPP came back and said there was no evidence on Edward Ouko,
right,
and recommended the prosecution of the Deputy Auditor General.
Okay,
now, when these things come back in Parliament and the manner in which they are rushed,
right,
compare that with the manner in which the Waiguru petition was treated. You remember the MP for Nandi Hills,
yes,
Keter, when he attempted to bring a petition on the impeachment of Waiguru, the Speaker told him that he needed to bring more evidence.
All
the
right,
manner in which this is being treated is a clear witch
hunt. All
hunt.
right, so clearly two very differing opinions, and you obviously, I assume, disagree with what Moses is saying, but we will continue.
Moses is lying to the country. First of all, the DPP
I think that's very
closed the file.
That's very unparliamentary language.
I think we're not in Parliament, Moses.
No.
If, when I was in Parliament before the Committee of Finance,
I think lying is a very strong word.
Appeared before the committee. And the DPP was categorical that he has not closed his investigation, he has not closed getting evidence. And should any further evidence be availed, either through the process that Parliament is going through or through EACC, he is open to look at that evidence and determine whether he has adequate evidence.
I think
very brief response,
since my brother here calls me a liar, which I strongly object to, if he were in Parliament, would have dealt with it differently. The DPP, at the point at which he came before his committee, had made certain recommendations, and that was that Edward Ouko was not to be prosecuted. Okay. Now, they are fishing for additional evidence. as at that point the DPP had made a conclusion.
All right, let's leave it there for a moment.
I don't think you need to, if it was in Parliament, I would have asked you to withdraw and
Okay,
apologize.
Gentlemen, we need to leave it at that just for a moment, but clearly so much more to discuss. Our conversation continues about the Auditor General, Edward Ouko, and whether he's being handed out of office or not. Remember, the hashtag is auditing the auditor, and with me in studio, Moses Kajwang, the Senator of Homa Bay, and also Kimani Ichungwa, the Member of Parliament for Kikuyu. Gentlemen, thanks very much for staying with us. Now, before we took that break, the issue of evidence came up, and really what the Auditor General is saying is that no evidence has been brought forward to indicate that really there is a case against him.
I think, Smriti, this matter is very simple because it's in pursuit of Article 251 of our Constitution. And we passed and adopted this Constitution in 2010, believing in it as Kenyans. And we truly believe that if we are to respect the independence of constitutional office holders and commissions, then we must create provisions within the same Constitution laying out the process and procedure of removal of officers of those independent commissions, basically just to make such officers comfortable that anyone in government or anywhere else will not just hound them out of office, and they have that constitutional protection. And therefore, the Constitution created that process. And the issue at hand is not even about the evidence, because the evidence will come in when you allow the process to roll out. Mm-hmm. Just the same way, whatever evidence he has in the court case he has taken, then he will go and prosecute that in court, but not in the media, in press conferences. Yeah. And I think that is the concern that we have. That now, my good friend and colleague in the profession, and I'll tell you, I'm an accountant of high standing in this country, also probably even better standing than the Auditor General. And I'll tell you, you do not do that if you truly want the truth to come out. You allow a due process to take place. Okay. And let me also point out, Smriti, that the issues at hand, I am not at liberty, of course, to delve onto the substantive issues of evidence at this point, because the matter, as has been said, is a matter before court, is a matter also pending before a committee of parliament. Therefore, I would really just want to see a situation where we respect the provisions that we have in Article 251 of the Constitution. Otherwise, we would rather than say we toss away the Constitution and we interrogate issues to do with the removal of independent office holders, not following the Constitution, but we can run to court or run to press conferences in every other street in this country. Well,
going back to the process, before then we, get to the evidence, like Kimani is saying, the Auditor General feels that he's not going to get a fair hearing by the committee. Why does he feel that way, do you think?
The same Constitution that has Article 251 also grants every Kenyan a right to a fair hearing and a right to fair administrative action. We in Parliament, we passed an act, it is now an act, the Fair Administrative Action Act. And that act lays out the processes and the parameters that should be engaged when giving a citizen fair hearing or when a citizen is going through an administrative action. So that is an argument that, that Edward Ouko has made. But I think the most fundamental issue here, we have a situation where the National Assembly has decided that we are going to make up our minds whether to obey a court order or not. That is a disaster. Justice Mwita made a ruling and he issued conservatory orders so that the relevant committee of the National Assembly would not proceed with entertaining that particular petition until certain matters were sorted out. Now you have the National Assembly sitting back and asking themselves, should we or should we not obey a court order? That is a beginning of anarchy in any state. Because that constitution, which my brother Ichungwa has talked about, talks about the separation and the balance of powers between the different organs. But there is no organ that has got absolute imperial rights and powers over any other. And that is why the legislature writes laws for interpretation by the judiciary, and the legislature comes up with issues for execution by the executive. There is a nexus around them. And so National Assembly cannot sit down. In fact, for me, that is the saddest bit, that the National Assembly and the Speaker today decided that he's going to make up his mind and communicate by Tuesday whether they're going to obey a court order or not. A court order must be obeyed.
I think, Smriti, first I appreciate that Senator Kajwang appreciates that within the same constitution there's something called separation of powers. And no arm of government should interfere in the workings of any other arm of government. And I think the right thing to do, and I don't want to interrogate again in media decisions made by a judge on TV, but the question of whether the judiciary can interfere with the issues before Parliament, I think the question of sub judice goes either way. There is also a question of whether Parliament can interfere with matters before court. And I think the precedent that has been set in the past is to allow the parliamentary process to be concluded. And I think I heard the Chief Justice himself the other day when in the leadership conference in Mombasa with leaders of both houses, the National Assembly, allude to something towards that end, that the judiciary allows the parliamentary process to come to a conclusion. Remember, Senator Kajwang, that is what happened during the Wambora case. The Wambora case impeachment went through Senate, and actually Senate impeached Wambora, and he went to court. Then the court then can question the judgment or the decision made by Parliament. And that's all I would have expected my good friend Edward Ouko to do. Allow the parliamentary process to continue.
So what do you think the reason?
Even before the committee even either recommends, depending on the evidence that will be adduced before the committee, then Parliament will make a decision as to whether to set up a ask the president to set up a tribunal, or even to dismiss the whole case altogether, depending on whether there's evidence. But the jittery nature in which I saw Edward Ouko and his good lawyer friend, Otienda Amolo, speak with at the press conference left me with very many questions.
So do you
is
think
there
he's
something that the
something?
Auditor General fears that will come out within this process in Parliament, and therefore wants to prosecute his case by himself in the court of public opinion, where nobody will measure the weight and the veracity of the evidence that might have been adduced? Remember, in press conferences, nobody will adduce any evidence.
Well,
in the petition, in Parliament, or even the matter before court, then evidence will have to be adduced. I would beg my good friend Edward Ouko, allow due process to take place. That is what Kinisu did. That is what the former Matemu, former chair of EACC did.
Well, we'll see.
And all the other commissioners have allowed themselves to be...
That is when, the Speaker of the National Assembly will then rule whether or not
to obey
Parliament
a court order.
I wish I was
will continue to deliberate or not.
Could I bring something? Because Article 251, we in the Senate, we've had an opportunity to test it quite a bit with impeachment proceedings against governors. Now, Kimani has talked about the Wambora case, which it's accurate. But there's also the Mwangi Wairia matter. Mwangi Wairia, I was a member of the impeachment committee, and we could not commence our sittings and deliberations until a matter that had been taken to court had been ruled upon, and I think it was Justice Onguto who ruled upon it. Because Mwangi Wairia rushed to court and said that he had not been proffered a fair hearing, the rules of natural justice, etc., etc. And the judge, yes, by the county assembly, and the judge made a ruling on that, and Senate was able to proceed. I don't think Ouko is talking about issues of evidence, because as far as is concerned, and he said it today, his conscience is clear. He just wants to be afforded a fair process, rules of natural justice, fair administrative action, so that these issues can then be dealt with. And again, Article 251, something that's important to bring out, that Parliament has established some precedents or contributed to the jurisprudence in the sense that when it comes to removal of constitutional office holders, we have set a very high threshold. Under what basis can you remove a constitutional office holder? One would be gross violation of the Constitution, and the word is gross. Two would be gross misconduct, and the word is gross. And three would be incompetence, bankruptcy, or ill health. So let's, if we can deal with the process and make sure that the process is clear, I don't think that Edward Ouko has stated any hesitancy to go through the prosecution by a committee or a
Right.
tribunal under Article 250.
Okay,
I
just
think
quickly.
Smriti, Senator Kajwang has done very well to bring the Mwangi Wairia case, because as you have clearly enumerated, is Mwangi Wairia went to question the process that he had been taken through by the county assembly.
Gentlemen,
And it is the county assembly that sent the petition to impeach him to the Senate.
let's
Therefore,
just bring
that was
it.
in order.
Yes.
Let's just bring it back to Edward Ouko's issue, because we do need to wind up now. As I said, on Tuesday, the Speaker will, of the National Assembly will decide or rule whether Parliament will continue to deliberate on this or not. If he says we will not deliberate on this going forward, then what?
Well, let me not preempt what the Speaker is bound to rule.
But if we look at yes and no.
Let me say, if I was a Speaker, if I was sitting in the Speaker's position, I would jealously protect the independence
Of
of
course.
Parliament, and I would definitely rule that the House has
But
every
if he
right
does not,
to listen.
If he says this is not going to be discussed,
Well, if he says it won't be discussed, then we will have to wait for the court process then to get finished.
so you just have to obey.
You just
the
have to obey.
Speaker's-
But,
all right.
well, of course, we have no choice but to obey the
Okay,
Speaker.
all
But
right.
I
And-
truly hope, and I hope the Speaker of the National Assembly is listening to my
And
wise
Moses-
counsel this evening.
If I was
rule.
the Speaker of the National
To
Assembly,
defend the
Not
independence
if you
of
were,
Parliament.
but if he rules it,
If I was the Speaker of the National Assembly, I would not selfishly safeguard Parliament. I will selfishly safeguard the Constitution.
Okay,
and
but
it
if
will
the
not
Speaker-
be
Which
it will
guarantees
not
that
be a
independence.
discussion on whether we should obey a court order or not. In
All right.
fact, he can even find out from President Uhuru Kenyatta with the hiring of police, which he had to reverse later on because he had ignored a court order.
Okay,
Court
and if
orders
the Speaker,
must be observed.
if the Speaker rules that Parliament can continue deliberating on this petition,
Then impunity would have won.
okay,
No,
let's
no, no.
leave it
Once
at that.
again.